Just some quick cases, and we'll wrap it up here for any questions. This BJ's Restaurant case, the court held that employers are not required to buy the black non-skid shoes that are required in restaurants. Said because they're just general uniform types of shoes they can wear at other establishments, the employer is not required to pay for those. Good ruling for employers. This Ward versus Tilly's case, I'm still getting a lot of questions about this, about reporting time pay. And here, Tilly's had a policy, it's a retail store, that the employees would have to call in 2 hours before their shift. They were required to call in 2 hours before their shift to see if they're required to come into work. The court said this was actually reporting to work when they called in to the employer. Because they called into the employer, reported to work, if the employer said you're not needed today, that triggered the reporting time pay, and the employer had to pay them reporting time pay. I think there's some arguments there if it's voluntary or not, but it created a lot of ambiguity on that issue. So if there's any kind of requirement to call in before the shift, there could be a reporting time pay on that issue. The Nike case, we're seeing this come up in some different industries, but Nike had the employees go through an inspection exit when they took breaks and left the store to make sure they weren't stealing merchandise. Took anywhere from a few seconds to a few minutes. The employees sued, saying they had to clock out before they went through these exit points. They sued, saying they weren't paid for this time, minimum wage violation, and overtime claims as well. The court actually said Nike tried to rely on the de minimis doctrine. It's a federal doctrine. The court said, nope, it doesn't apply. We had a Starbucks case last year that said that doesn't apply in California. The California Supreme Court left it open to a certain extent. Maybe it could apply in some circumstances. They didn't explain what circumstances, but the court here in Nike said it doesn't apply in this circumstance. It was some period of time. The employer knew about it. It's calculable. The employees should be paid for that time, or could be paid for that time. The case is still ongoing. It wasn't a merits determination, but this de minimis doctrine did not apply. Now, that was the exact same issue in the Starbucks case, where the California Supreme Court said the de minimis doctrine does not apply in California. The manager would turn on the alarm. Sometimes somebody would forget a jacket. They'd have to let them back in. And they said this was all time that the employer should have tracked and paid them for. So some policies I recommend putting in place for that is obviously having them clock out as late as possible before they have to do any other tasks. And then having a fail-safe too. Look, if you clock out because you have to clock out on our POS system, but you work longer, add some extra time, 5 minutes to each of their shift. And if you're doing that, now the burden's on the employee to say they worked longer. And you can talk to the employee and say, look, if you have any complaints, let us know. If it's longer than 5 minutes, let me know. And if they never let you know, you can say, look, we added 5 minutes. They never let me know that it was any longer than that. And that's a good defense there. And I think you're going to go a lot longer in that case.